RPAPL 701, a special proceeding to recover real property may be maintained in 1. The county court, 2. Court of a police justice of a village, 3. A justice court, 4. A district court, 5. A court of civil jurisdiction in a city.
RPAPL 711, a tenant shall include a non-transient occupant of one or more rooms in a hotel who has been in possession for 30 consecutive days.
A lawsuit to recover real property may be brought by
1. Landlord or lessor. 2. Revisioner or remainder man, estate of a life tenant. 3. Purchaser upon execution or foreclosure sale. 4. Person forcibly put out or kept out. 5. Owner of the property under an agreement to cultivate property for share of crops. 6. Person lawfully entitled to property intruded or squatted upon. 7. Person entitled to possession occupied by a licensee who may be dispossessed. 8. Person, corporation, or law enforcement agency authorized to remove persons for illegal purposes. 9. Receiver of a landlord, purchaser, or other person entitled to apply when authorized by the court. 10. Lessee of premises entitled to possession. 11. Not-for-profit corporations, tenant associations charged with enforcement of housing maintenance in the city of New York.
Question 7, RPAPL 735-2. The notice or petition or order to show cause and petition together with proof of service therefore shall be filed with the clerk and with the court or clerk thereof within 3 days.
What number?
You're on 8.
Oh, 8? Okay.
Are you ready? Tell me when you're ready.
8. RPAPL 7012. The place of trial of a summary proceeding to recover possession of real property shall be within the jurisdictional area of the court in which the real property or a portion thereof is situated, except that where the property is located in an incorporated village, which includes parts of 2 or more towns, the proceedings may be tried by a justice of the peace of any such town who keeps an office in the village.
In general, in a holdover proceeding in the city of New York, the court, on application of the occupant, may stay the issuance of a warrant and also stay any execution to collect the cost of the proceedings for a period of not more than 6 months. If it is outside the city of New York, it is 4 months.
RPAPL 749-2. The officer to whom a warrant is directed awarding possession shall give at least 72 hours notice in writing to the person or persons to be evicted.
That excludes Saturdays, Sundays, and public holidays.
Yeah.
72-hour notice that the officer to whom a warrant is directed awarding possession has to give 72 hours notice in writing, and that does not include Saturday, Sunday, or public holidays. The notice of petition shall be made returnable before the clerk within 5 days after its service.
749. Upon rendering a final judgment for petition, the court shall issue a warrant eviction directed to the 1. Sheriff of the county, 2. Any marshal or constable of the city in which the property or a portion thereof is located, and 3. If it is not situated in the city, to a constable of any town in the county.
Just check that it's still taping.
Read it loud, right?
Am I reading too low? Yeah. RPAPL 749. The following are true concerning a warrant of eviction. The warrant must describe the property. It must command the officer to remove all persons, and except where the case is within section 715, to put the petitioner in full possession. The issuing of the warrant cancels the agreement under which the person removed held the premises and the annals of the relationship of landlord and tenant. The officer to whom the warrant is directed shall execute the warrant between the hours of sunrise and sunset.
In a holdover proceeding, acceptance of rent after commencement upon this ground shall not terminate such proceeding nor affect any award of possession to the landlord or new lessee.
RPAPL 711 sub 2. In a non-payment proceeding, the landlord must make a demand for rent or at least 3 days' notice in writing, requiring in the alternate payment of rent of possession of premises.
RPAPL 711. A tenant shall include an occupant of one or more rooms in a rooming house or a resident, not including a transient occupant of one or more rooms in a hotel who has been in possession for 30 days or longer.
17. 711 sub 2. A special proceeding may be maintained under RP RPAPL Article 7, where defendant has defaulted in the payment of rent, I think they mean respondent, pursuant to an agreement under which the premises are held and a demand of the rent has been made, or at least 3 days' notice in writing requiring in the alternative the payment of rent or possession of the premises has been served upon him as prescribed in 735.
So this is like, so a 10-day notice to quit is there's no relationship, but if there's this rent relationship, it's basically like a 3-day notice.
Yeah.
RPAPL 732, in a special proceeding brought on the grounds that a tenant has defaulted on the payment of rent, if the respondent answers, the clerk shall fix a date for a trial or hearing not less than 3 days nor more than 8 days after joinder. 732, in a special proceeding brought on the grounds that a tenant has defaulted on the payment of rent. If the respondent answers, the clerk shall fix a date for trial or hearing not less than 3 days nor more than 8 days after joinder of issue, and shall immediately notify by mail the parties or their attorneys of such date. If the determination for the petitioner, the issuance of a warrant shall not be stayed for more than 5 days from such determination. If the respondent fails to answer within from the date of service, the judge shall render judgment in favor of the petitioner and may stay the issuance of the warrant for a period not to exceed 10 days from the date of service.
19 RPAPL 733, except as provided in section 732, except as provided in section 732, relating to a proceeding for non-payment of rent, the notice of petition and petition shall be served at least 5 days and not more than 12 days before the time at which the petition is noticed to be heard.
RPAPL 731. The special proceeding prescribed by Article 7 of the RPAPL shall be commenced by petition and notice of petition. A notice of petition may be issued by 1. An attorney, 2. The judge, 3. Clerk of the court. And that's it.
RPAPL 755B and C2. Upon proper proof of the existence of a condition that in the opinion of the court, such as to constructively evict the tenant from a portion of the premises occupied by him or is likely to become dangerous to life, health, or safety, the court before which the case is pending may stay proceedings to dispossess the tenant for non-payment of rent or any action for the rent or rental value. The tenant shall not be entitled to the stay unless he shall deposit with the clerk of the court the rent then due, which the purposes of this section be deemed the same the tenant was liable for during the preceding month. The stay must be vacated upon 3 days' notice upon failure to deposit with the clerk the rent within 5 days after it is due during the pendency of the proceeding or action.
Good
All right,
job.
I didn't
That was
know
a
that
long
one.
one. 732 sub 3. If the respondent fails to answer within 5 days from the date of service, the judge shall render judgment in favor of the petitioner and may stay issuance of the warrant for a period not to exceed 10 days from the date of service.
732. If the respondent answers, the clerk shall fix a date for trial or hearing not less than 3 days nor more than 8 days after joinder of issue, and shall immediately notify by mail the parties or their attorneys of such date. If the determination be for the petitioner, the issuance of the warrant shall not be stayed for more than 5 days from such determination.
RPAPL 745, where triable issues of fact are raised, they shall be tried by the court unless the time the petition is noticed to be heard, a party demands a jury trial, in which case trial shall be by jury. Under certain circumstances, the court may adjourn the trial of issue, but not more than 10 days, except by consent of all parties.
If the proceeding is founded upon an allegation of forcible entry or forcible holding out, the court may award to the successful party a fixed sum as cost not exceeding $50 in addition to the disbursements.
715 sub 5. If a person subpoenaed to attend upon a proceeding under RPAPL 715-5 conducted by an enforcement agency of the state fails to obey the subpoena without reasonable cause, he or she shall be guilty of a Class B misdemeanor.
RPAPL 745. In general, outside the City of New York, a court may adjourn a trial involving an issue of fact under a proceeding commenced under RPAPL Article 7, but not more than 10 days, except on consent of the parties.
749. The following are true regarding a warrant issued pursuant to RPAPL Article 7. It may be executed between the hours of sunrise and sunset.
Any proceeding under Article 7 RPAPL, if a stipulation is made on the occasion of a court appearance setting forth an agreement between the parties, and either the petitioner or respondent is not represented by counsel, the court shall fully describe the terms of the stipulation to the unrepresented parties, unless the stipulation is solely to stay or adjourn the proceedings.
This is when a special proceeding may be maintained under a holdover. The tenant in a city defaults in the payment of any taxes or assessments levied on the premises for 60 days after the same shall be payable, for which he has agreed in writing to pay pursuant to the lease agreement, basically, and a demand for payment has been made, or at least 3 days notice in writing requiring, in the alternative, the payment thereof, and of any interest and penalty thereon, or the possession of the premises has been served upon him, as prescribed in 735. Acceptance of rent shall not be construed as a waiver of the agreement to pay taxes or assessments. 715. Grounds and procedure where use or occupancy is illegal. Legal. And it basically says that neighbors within 200 feet from a bawdy house or a prostitution house or any illegal trade, business or manufacturer, or a domestic corporation organized for the suppression of vice who has a certificate from DSS can make a notice to the owner or landlord directing them to commence a proceeding under this article to remove the prostitutes and occupants. And if they don't make it within 5 days after getting the notice, or they make it but they don't diligently prosecute it, the neighbor, corporation, or enforcement agency giving the notice can actually bring the proceeding to remove those people. And they would make the landlord or owner a respondent as well as the persons in the bawdy house. A court, in granting a petition pursuant to this section, in addition to any other order provided by law, can make an order imposing and requiring payment by the respondent of a civil penalty not exceeding $5,000 to the municipality in which the subject premises is located, including attorney's fees, and if there's more than one respondent, they're jointly and severally liable for this. And the amounts of such payments shall constitute a lien on the subject's realty. This goes on to say the thing about if you fail to obey a subpoena pursuant to this section, you'll be guilty of a Class B misdemeanor. 713-A just says that a proceeding to remove an adult resident from an adult home is maintained pursuant to social services law, and nothing in this article is deemed to create a relationship of landlord and tenant between the operator of an adult home and a resident thereof. Grounds where landlord-tenant relationship does exist. Holdover type 1, where the tenant stays past his lease. Holdover type 2, where the landlord establishes by competent evidence to the court's satisfaction that the tenant is objectionable, and that can terminate the lease agreement. 3, non-payment of rent. This includes a tenant who has died and no executor or administrator has been appointed, in which case the proceeding may be commenced after 3 months from the date of death of the tenant by joining the surviving spouse, or if there is none, then one of the surviving issue, or if there is none, then any one of the distributees. 4, the tenant in a city for 60 days defaults in payment of taxes. 5, a tenant under a term of a lease of 3 years or less has taken the benefit of an insolvency statute or has been adjudicated a bankrupt. 6, the premises or any part thereof are used as a bawdy house or prostitution. 7, the tenant in New York City disables the smoke detector, and subsequent to the 30th day after service of an order directing him to put it back together, is served upon the tenant to get an official report by the Department of Housing Preservation and Development indicating non-compliance, provided further that the tenant shall have an additional 10-day period to cure such violation. There are 2 exceptions in 713 to the 10-day notice to quit. The first one is the Viking, where someone is taking possession by force or unlawful means, and was not in quiet possession for 3 years before the time of the forcible entry or unlawful detainer. Incident to employment by employment has been terminated. So the vendee, seller, life tenant, foreclosure, unpaid taxes, squatter, sharecropper, execution sale, all of those requiring of a 10-day notice to quit. But the Viking and the employment one is no 10-day notice to quit.